Welcome to Sakshi TV special immigration talk show with attorney Ms. Prashanthi Reddy. Please know that Sakshi TV now has 3 immigration shows every week. On Wednesdays with Prashanthi Reddy in English, on Thursdays with Chand Parvat Nini, and on Fridays with Banu Nindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. But if you need any specific legal advice, you can definitely contact the attorney directly. Ms. Prashanthi Reddy needs no introduction, but if you need consultation, you can definitely log on to their firm, which is www.reddyesq.com. They provide you with a wealth of free information and online tools for the hands of immigrant community. So if you have any doubts or queries, you can definitely contact her. Without any further delay, let us welcome Prashanthi Reddy Garu on our show. Reddy Garu, I hope you're doing well.
I'm doing well, Shivani. How are you?
I'm doing great. Thank you so much for asking, Ms. Reddy. Ms. Reddy, so today we thought we will, kind of talk about something related to business and what will happen if you do business in USA for a newcomer. But before we get into, do we have any latest immigrations that we have to, find, or can we get on with the topic?
Well, just a quick immigration update about the visa bulletin for the month of November. So the visa bulletin has come out, and there is not much to talk about because there's not much change in the visa bulletin from last month. Pretty much it's status quo for EB1, EB2, EB3 for India as well as worldwide. And just as it was in last month, this month as well, USCIS has indicated that the dates for filing table has to continue to be used. So if your priority date is has reached the dates for filing, the dates as per the dates for filing table, then you can go ahead and file your 485 adjustment of status. And if you're out of the country, you'll most probably get a call for an immigrant visa interview.
Okay, great. So, Ms. Reddy, let's continue with the topic. So my first question to you is, can anybody start a company in USA? Let's say if they're on a H1B or even an F1 visa, can they start their own company or business in USA? Or do they have to have a green card, or should they be a citizen of USA to start their company?
So the problem with the H1B visa in particular, or the H1B status, is that it is directly related to your employer who sponsored your H1B. So you only have to work for the employer that has hired you and has filed your H1B petition. So there are a lot of rules and regulations surrounding the H1B petition. And one of them is, in addition to having to pay the prevailing wage, etc., work location, specialty occupation, meaning that you have to work in a specialty occupation. One of the more important ones pertaining to your question is that there has to be a clear employer-employee relationship. So therefore, you can't be the employer and the employee, so you can't, do business on your own, because then you're restricted by the H1 to only work as per the terms and conditions of your H1 for that particular employer who has filed your H1. So doing business is difficult. If you're on a H1, being an entrepreneur is difficult. You can invest passively. So you can buy shares in a company. You can buy, you can purchase shares in the stock market. You can invest. You can invest in a private enterprise as well, as long as you're just a sleeping partner and you're not managing the day-to-day affairs of the company. So can you be an entrepreneur? Yes and no. You can be an entrepreneur in the sense that you can invest indirectly. You can invest directly but not work for the company. But you can't, as an entrepreneur, run the company and take care of the day-to-day operations of the company. I hope that's clear.
Yes. What about the dependence of the H1B visa or the F1 visa? Because you see, there are a lot of people who start their small cooking business or a restaurant or these catering services. Because I have seen a lot of NRIs doing that. I don't know if they're doing it for the part time or full time. What role or what advantages can these dependents have?
So H1 dependent is a H4. And H4 actually has more leeway to work than the primary applicant, which is the H1, which is really surprising because they derive their status, after all, from the primary applicant, and you would think the primary applicant would be in a better situation to work. But actually, the dependent, if provided the spouse, the primary sponsor, has an I-140 approved, then the dependent can actually get an EAD, can apply for a H4 EAD. And based on that employment authorization document, they can work for any employer. The work is not restricted to one employer like it is for the H1. That's why I was saying the terms and conditions for a H4 EAD working are much better than they are for the spouse, which is kind of ironic. But so the H4 EAD can do any kind of business, as you said, can open their own shop, can invest passively as well as actively, can run the business. Everything that an entrepreneur wants to do, the H4 EAD can do. They can take care of that. Now, with reference to the F1, when the student is working, they can work on campus, of course, but they cannot work off campus unless they have special permission from USCIS. And that permission is basically called curricular. It's given in the form of curricular practical training. So they can get a CPT, but the restraints of a CPT is that they have to work within the area that they are studying in. So they have to show that the work somehow complements their study. So CPT is possible, but in the CPT also there has to be an employer and there has to be an employee. So I don't think it'll work if you say that they're self-employed. So that's something to think about. Another instance where an F1 can work is if they're on OPT, optional practical training. This could be two types of OPT. One is post-completion. After you finish your degree, you get 1 year. And then you get an extension of 2 years if you're in the field of science, STEM, science, technology, engineering, and math. So even in this OPT, there are restrictions on what you can or cannot do. It has to be, again, related to your field of study. And there has to be an employer. So I think even in this situation, self-employment may not be an option. Even though with reference to, again, going back to the H1, whether the H1 can work for themselves or not as an entrepreneur, some regulations say that the H1 can be self-employed. But again, there are other regulations which say that there has to be an employed-employee relationship. So I would go with the latter, and since even though it says it somewhere, as a matter of practice, really, the USCIS is looking for an employer-employee relationship. So there has to be a distinction between the employer, that's your company, and the employee, which is you. So that kind of rules out self-petitioning in the H1B situation.
Yes. And also, Ms. Reddy, I got this doubt. Can somebody who has a full-time H1B work again part-time? Because again, there are few cases that I kind of read online that people, they do part-time, in their midnights, maybe to get their extra income. So for that, do they have to have two different H1Bs? And also, there were multiple registration frauds that happened a couple of months ago, and the number was really high. And so is that under this the same context, or is this a completely different new thing that people can know?
So H1B, two different things, and I'll address both. So with reference to the H1B employee being able to work with more than one job, that is, yes, it is absolutely possible. So as long as you file a concurrent H1. So you have to file an additional concurrent H1, and when you're filling out the I-129 form, you have to mark it as a concurrent petition, not as an extension or a transfer, because if you do a transfer, that means your old petition will no longer be valid. In this case, both petitions will be valid. So you're filing, you already have a H1, may say for full-time maybe, and you're filing another H1 for part-time. That is possible. And also the advantage of a concurrent petition is that concurrent petition does not have to be under the cap, which means if you already have one H1B petition, and if that H1B petition is cap exempt, meaning that you're working for an organization, non-profit, educational organization, etc. Now, if you want to get another H1B petition, that does not have to be subject to the cap. You can work for a for-profit organization as well, as long as you're maintaining that other, the other H1B petition, which is a non-profit H1. So it's an interesting scenario where this is the only situation where, when you file a concurrent H1, that concurrent H1 is not subject to the cap, unlike filing a regular full-time standalone H1. So that's another interesting nuance to point out in concurrent H1 situations. And yes, during COVID and during other times as well, it's quite common for people to hold more than one job. It could be one full-time, one part-time, it could be two part-times, it could even be two full-time jobs if they're able to do it, if they're able to put in the hours. So yeah, that's with reference to the concurrent H1s.
Yes.
And Shivani, with reference to the multiple registrations, with reference to multiple registrations, a registration process is the process whereby you put in your name for the lottery for the H1B cap process. So as we all know, the H1B numbers are limited to 85,000, 65 for the regular petitions and 20,000 for the master's cap petitions. So what happens is USCIS conducts a lottery, and before they do the lottery, they have people register for the lottery. So when you register for the lottery, last time what had happened is multiple beneficiaries filed multiple registrations so that they could get a better chance at getting picked at the lottery. That is allowed by USCIS because USCIS allows you to have more than one job at a time, file more than one H1B petition at a time, right? So that is allowed. However, multiple registrations by employers is not allowed, meaning an employer cannot file two registrations for the same employee. And an employer also cannot for example, talk to another employer and say, oh, look, you file the same petition, collude with another employer and say, look, you file these 10 petitions, I'll file these 10 petitions, and we'll file the same petitions. And then when we get the responses, and if someone gets picked, we'll, share the profit, or we'll, share the employees, etc., etc. That's collusion, and that was not allowed under the registration process. And some people did it knowingly or unknowingly. And a lot of beneficiaries filed multiple registrations. There's some beneficiaries that filed 10, 20, 30, 50, 70 registrations. So this year, what they're planning to do, rather this fiscal year or next March, is, and hopefully it'll be implemented soon, but they're planning to have only one pick at the lottery for the beneficiaries, no matter how many registrations they file. So the lottery will be based on the beneficiary's passport ID number and not based on the number of registrations they file. So they'll only get one bite at the apple. And so that will remove, the disadvantage or the advantage of filing multiple or one registration. So that's the story of multiple registrations.
Yes. I think, Ms. Reddy, when I was kind of like researching about these kind of visas and, especially business related, the one thing that popped up was EB5 visa. So can you explain or give a introduction about what exactly EB5 visa is?
Yeah, so EB5 visa is an investor visa, and usually these investor visas are filed by people who have money and people who want to invest in the US, and also people who want to start a business in the US and want to migrate to the US and get a green card. So with reference to the investor visa, it's the investor visa amount keeps changing, but it was 500,000 if you're in a targeted area, meaning an area which has a very low employment rate, meaning a lot of people are unemployed in that area, then the amount is lesser. And if it is a regular area, then the amount is 1 million. So they're called TEAs, targeted employment areas. So you have to invest that amount of money and you have to hire a certain number of employees, right? So that is the, and then if you show that you're able to do that, or you have the potential to do that, and that you have transferred that amount of money, and if you're able to show, the type of business that you have opened, etc., then you will get, and that's a lot of information that I can give you on that EB5, and we'll have to have a whole session just for that. But just to give you, in a nutshell, once you have done that and once you qualify, you get a temporary green card. And then after 2 years, you can remove conditions on that green card, meaning if you still qualify and if you can show that you're still meeting all those conditions and requirements, then you get a permanent green card. But just to keep in mind, the processing time for EB5s is very, very lengthy nowadays. It's taking 3+ years just for them to process the case, the initial step. And by then, a lot of things can change. Businesses will change. They'll open, they'll close. Ownership changes, investment, everything might change. So that's something that is affecting the EB5s, the processing time. And, by the time the entire process is over, it takes about 10 years. But I guess EB5 is still a good idea for people who just want to invest and who are not planning to open a business. But if you want to actually open a business in this country, then an L1 is really a good option because there's no minimum or maximum investment amount. You'd invest as much as you need to, as long as it makes sense for the type of business that you're opening. You get a green card fairly quickly because you can first come as a non-immigrant, as an L1, and then you can convert to a green card after a year. And even though for Indian nationals it's not current right now, it's not too bad. So it's faster than an EB5, let me just put it that way. So it can take a few years for you to get a green card. So that's another option for investors or people who start businesses to come into the US. So the two options are the EB5, and there are advantages and disadvantages to that, and the L1. And there are advantages and disadvantages to that also. There's a lot of documentation that has to be shown for the L1. You have to show that you're working in an executive position in your company back home, and that company back home is transferring you to their parent or subsidiary in the US to work in an executive or managerial condition. And there's a lot of documentation and explanation that you have to give to prove that it's actually an executive position, and to show that there's a relationship between the two companies, etc. So there's a lot of documentary evidence that has to be provided for an L1A.
Got it. So you were saying that for you to have an L1, you have to have a company already set up in India or their respected country, and then that will be for the executive. So, right, Ms. Reddy?
Yes, that's correct. So you have a company in India, and then you want to incorporate a company in the US, right? Maybe you haven't incorporated one yet. You want to, or you've just incorporated but have not started business. So you want Mr. X to come from company in India to company in the US to help set up operations.
Got it.
As a manager or operations manager, director, or whatever the title, executive title it might be.
Got it. So what about, my question is, I don't know if that is really silly or something simple, but my question is, what about the people who want to genuinely start a business who don't really have a lot of money from India? Do they have any special visas, or or anything for that?
There is something called an investor visa, but that is a temporary visa given, they're given advance parole, and it's a very temporary, and not many people are using it, and there are terms and conditions for that also. It's quite complicated again, and not possible to explain in this session, but there is another one called an investor visa, but it doesn't give you a particular status, or it doesn't give you a pathway to a green card. It just allows you to stay in the US for a temporary period of time. So these are the three types of ways that an investor or a business person can move to the US.
I think, of course, we can have another session where we can deeply discuss more about this. I think a lot of viewers might like it. My other question to you, Ms. Reddy, is, again, there were a lot of multiple registrations that happened a couple of months ago. And I don't know, I think USCIS kind of got into it all of a sudden. It was like the people were removed or were laid off from their jobs. So what was the situation back then, and how is the situation right now? How is the layoff situation happening? And of course, once you are removed from a job, you do get 30 to 60 days of time, if I'm not wrong. I might be wrong. But yeah, again, 60 days of time. How quickly do they have to get a new job, or what is the situation there?
So layoffs did happen in a lot of big companies this year, and the job market seems to have stabilized now. But this is part of the process, right? There's always layoffs, and then people get rehired. So in the United States, it's all part of business. Big companies hire more people than they need, and then when they don't need them, they pretty much lay them off, right? So luckily for people who are on a H1, there is a change. There is a new law which came out, which allows them some breathing room if they're laid off. So in the past, what would happen is that even if you were laid off even for a day, then you fall out of status. You're out of status. You have to leave the country. You only have to depend on a nunc-pro-tunc application. So you're basically on humanitarian grounds. You're filing an extension or a new petition after the person has been laid off and doesn't have any pay stubs, hoping that in those circumstances, the USCIS officer will show some pity and on human grounds will approve the case, right? So that was the only fallback earlier. But now they have come up with a new law whereby they're giving a 60 days grace period within which a person can find a new job, or they can change their status to a different status to remain in the country. Or they can spend the entire 60 days just looking for a job. If they don't find anything, they can leave the country. So that's what the 60 days grace is for. It's for breathing time. It's for time for them to figure out what they can do. And also it's difficult as soon as you lose your job to just get up and leave, right? You might be owning a house, you might have a bank account, you might have to take care of all your affairs. So even for that purpose, this 60 days
I'm
grace
sure
helps.
even these people have kids there, and I don't know how easy would that be, because if their kids are born in the US, they are automatically the citizens of the US. So how do these people tackle this? Like, can you?
So yeah, I mean, people going to school. I mean, kids going to school. They'll be in the middle of their school year. But US citizen children, unfortunately, cannot do anything for their parents unless they become 21, they become adults, and then they can file for a green card for them. You have parents of US citizen children, which is an immediate relative category, so you can get your green card, without having to wait for any visa numbers. So there's no requirement for a visa number or green card number. So just the processing time. So that is an advantage of having a US citizen child, but not an immediate advantage. They have to wait until they become an adult to take advantage of that. The another advantage of having a US citizen child is if there is any humanitarian relief that you're seeking, like a waiver from being removed, say you've done something wrong in the US, you've committed a crime, you're being removed from the country, you can possibly file a waiver that you have US citizen children and there's a hardship to the US citizen or a spouse, and therefore you should not be removed from the country immediately. Right. So that is some things that are helpful if you have a US citizen child, but it's limited.
Yes. So finally, Ms. Reddy, anything that you want to say to people who want to start their business in USA and want to be a successful entrepreneur there? Anything as a lawyer that you want to say to the viewers watching?
Well, the United States is the land of opportunities, and it continues to be so. The only problems with the stringent immigration scenario, it's difficult for entrepreneurs to fulfill their vision and to do what they want to do. They're always restricted or bound, by their immigration status, and that's a reality. And it's in the best interests, I think, of the United States to open up some more visas or numbers, or create more categories, or make it easier for businesses to come and invest in the US, because when those businesses come and invest, not only do they provide jobs, but the GDP, of the country goes up, right? So another way, which I hadn't mentioned earlier, is also the B1. You have a business visa, the B1 non-immigrant visa that you can apply for if needed. And this B1 allows you to, if you get the visa, which not everyone will get, but if you get the visa, you'll get it for most probably a multiple entry for 10 years, and then you have to file for an extension. And now that you have visa waiver in place, and at least until the end of this year for extensions, you may not have to go for an interview again. So having said that, the B1 becomes an easy way of entering and exiting the country. Of course, you cannot stay in the US, but you can enter, solicit business, maybe take care of your company. If there's someone else taking care of it, then you can come and oversee it from time to time. So all these things are possible on a B1 visa. So that's another way of coming into the US as well.
Yes. I think that's it for now, Ms. Reddy. I think we did have a very informative episode. Probably anytime soon we can discuss more, especially about these business visas in detail. And I'm sure the viewers will like it. Thank you again, Ms. Reddy, for tuning in. It's always lovely to have you on our show. Thank you for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.
Thanks, Shivani.